As an estate and elder law attorney, one of the things we see a lot is that people make mistakes in doing their estate plan. My name is Bill Miller, and I'm an estate and elder law attorney here in Alabama. I have offices in Birmingham and in Anniston, and I'm going to talk about the 7 most common mistakes we see when people do estate planning. So first of all, the biggest mistake people make is that they have no plan at all. They just think they're going to live a long time, they don't need any plan, and then something suddenly happens and their family's left with the burden of them having no plan in place and no instructions. And then kind of a secondary mistake is that people may have a plan, but they've not updated it in years, so failure to update their existing plan is a big mistake. As your circumstances change in life, then your estate plan needs to change to reflect some of those changes. The second biggest mistake we see people make is they plan for death, but they don't plan for disability. So what do I mean by that? Well, many people will have a will which tells us what happens to your stuff when you pass away, but they have no documents or plan in place if they live a long time and can no longer make decisions for themselves. People now live into their 80s or 90s, and often when that happens, they become incapacitated or incompetent, but they have no documents in place to allow trusted loved ones to manage their money or their health care decisions if they're not able to make those decisions, and as a result, the family has to go to court to do that. The third mistake we see people make is they don't plan for long-term care expenses. Long-term care expenses are the biggest threat to your nest egg, and if you don't have a plan in place that accounts for those expenses, then your plan is not complete. The fourth mistake we see people make is they fail to recognize all of their creditors and predators, and what I mean by that is there are people out there who would like to get your money that you might not otherwise want to have it. For example, you might scrimp and save and leave your daughter a big inheritance, but she's got a rocky marriage, and when you pass away and leave her a lot of money, a year or two later, she and her husband get divorced, and now your son-in-law you never liked to begin with has half of your assets. So you did not prepare for potential predators. There are other examples, but that's just one of them. Another mistake we see people make is they'll put their kids' names on their bank accounts as co-owners. Well, they do that because they want them to be able to access the account if they become incapacitated. But the problem with that is that once they're on your account as a co-owner, then that money is subject to their creditors and predators. So, for example, if you have your daughter's name on your account, maybe $150,000 savings account, and she gets divorced, then the divorce court could take some of that money to help satisfy her divorce. Or if she had a tax lien or filed bankruptcy or got sued, your money can be used to satisfy any of those creditors because she owns the asset the same as you do. Another mistake we see people make is they leave everything outright to their heirs. Well, if you've got a child or grandchild who has an addiction issue, you can't leave them money outright, because if you do, then when they get the money, it's going to potentially just speed up the addiction. If it's to drugs, it might speed up their death. If they have a gambling addiction, the money could be gone in no time while you've scrimped and saved. So there are ways to leave heirs, your children, grandchildren, leave their inheritance in a trust or some other way so that they don't get it and have discretion about what to do with it. And then finally, another mistake we see people make is that they don't work with qualified professionals. Now, this is largely the attorney's fault, but every lawyer isn't an expert at everything. And so if you work with a lawyer down the road who just knows how to draw up wills basically, but doesn't put the provisions in your will that you need, then your will or your power of attorney or your advance directive may not be adequate when you need it. I have a lot of lawyers who write up wills, so to speak, that refer clients to me because I do this all the time. This is what I work on, and my wills and my documents have these things in it that people need. So people make mistakes when they do estate planning. I commend you if you have a plan, but I would advise you to have an expert look at it, a lawyer who specializes in estate planning and elder law. I'm happy to look at it. If you'd like to learn more, I would encourage you to register for one of our free estate planning asset protection workshops, or give us a call at 256-472-2172 and make an appointment, and I'm happy to help.